will now be on the record in 23 TR 2777, State of Kansas versus Anthony Edward Dubus. Jared Regier for the state. Is Mr. Dubus present? Anthony Dubus?
I am Anthony Edward Dubus. Dubus is the English pronunciation. Dubus is the original French. And I am appearing specially in propria persona, not pro se, as sui juris.
Okay, first of all, I can't see you, so you're not here.
Parents satisfied?
Thank you, sir. Now,
absolutely.
As far as I need to go, well, we need you back here in person.
Okay, well, it's propria persona, not in person. I'm not the legal entity that you're claiming me to be.
All right, sir, if I can't get you on camera, you're not here.
I'm doing so right now. I'm just removing it as it's taped. It takes a while.
Now, the second order of business, let's get your name straight. I know a family with the same exact spelling in America, and they do pronounce it Dubus, but you said you pronounce it
Dubus, as the original Dubus, as the original French. Yep.
Very well.
Buckle up, guys. This one is wild. Today, we're in Kansas, where a sovereign citizen named Anthony Edward Dubus, or is it Dubus, is about to test the patience of a very composed, but clearly no-nonsense Judge Webster. From the moment this hearing starts, it's a showdown between sovereign rhetoric and judicial reality. We've got debates over French pronunciations, legal identities, fictitious jurisdictions, and even a good old-fashioned trust administration accusation. This isn't just a traffic case. It's a full-blown constitutional cosplay. So stay tuned, because this one spirals fast and hits every note on the sovereign citizen bingo card.
In person. And
correction, in all courts, it may be either pro se, either appear in person, or propria persona.
Well, in my years of law school and nearly 40 years of practice, both as an attorney and a judge, it's been in person, and that's what I'm going with, sir. I believe that is just fine. So in any event, we will proceed with your charges. In count one, sir, you're charged with operating a motor vehicle on a highway of this state without having a valid driver's license pursuant to KSA 8-235A. In count two, it is alleged that on or about the 17th day of August, 2023, in Butler County, Kansas, you did then and there unlawfully operate or attempt to operate a motor vehicle, to wit, a 2003 Honda Accord, upon a highway of the state, to wit, 1700 block of East Foxtail Street, Andover, Butler County, Kansas, while the vehicle was not registered in violation of KSA 8-142. In count three, it is alleged that on or about the 17th day of August, 2023, in Butler County, Kansas, Anthony Edward Dubus,
Thank you, Mara.
did then and there unlawfully and intentionally drive a motor vehicle upon a public highway or property open to use by the public and failed to provide proof of insurance upon demand by a law enforcement officer. Now, sir, if you had insurance when you were stopped but just didn't have it with you or couldn't find it quickly, just provide proof to the county attorney and they'll most likely dismiss that charge. But if you really didn't have insurance, you're looking at a Class B non-person misdemeanor. The law does require a minimum fine if you're convicted of $300 up to $1,000, and it does have a possible jail sentence up to.
The judge is calmly trying to ensure the defendant understands his basic rights, like the right to counsel. But instead of a simple yes or no, we're veering straight into sovereign territory. Notice how he sidesteps responsibility by trying to split hairs between the named defendant and his living man persona. It's a tactic straight out of the sovereign citizen playbook, confusing identity with legality. Unfortunately, judges have seen it all before, and this approach never works the way defendants think it will.
If you cannot afford an attorney, you can apply and see if you qualify for a court-appointed attorney. You don't have to have an attorney, though. You can waive your right to an attorney and represent yourself. So that's an order of business we need to take care of today, is whether you want an attorney or not. And then another is to make sure that you understand what the charges are and the possible penalties. Do you have any questions for me about that?
Yeah, I don't understand the nature and cause of the charges. I have not had my accuser face me to bring the charges against me, as is a violation of due process. And I want to correct, for the record of the court, the named defendant is different than the named person, being myself. Hold on, let me make sure I get that in view of the camera. The named person here is different than the one named in the charges and the counts, being a difference of representation of who exactly it is the charges are against. And it is to my belief and knowledge that per KAR 8243 subsection A, exemption from the motor carrier safety regulations, A, the occasional transportation of personal property by private motor carriers that is not for compensation and is not in the furtherance of a commercial enterprise. I am exempt from these rules and regulations, and if I need to get a USDOT number to show that I was not operating a commercial motor vehicle or as a common carrier for business or for profit or in the furtherance of a commercial enterprise, I will be more than happy to produce that USDOT number to show that I am in fact a private motor carrier, not operating in commerce, not driving.
In the rabbit hole when they bring up the US dot number in a misdemeanor traffic case. The defendant claims he's a private motor carrier not subject to commercial laws, as if that somehow invalidates the state's ability to regulate basic driver licensing. But here's the problem: this isn't a commercial law case, it's criminal court under Kansas statutes. And no amount of pseudo-legal language will turn a Honda Accord into a commercial freight truck.
Uniform Commercial Carriers Code as adopted by the state of Kansas. You are charged just as a motorist operating a motor vehicle. Again, not a commercial vehicle. These are not laws that are subject to the commercial code or to the administrative regulation that you referred.
Although you mentioned the word operating, operating is a term used for the furtherance of a commercial enterprise, or driving, operating, the physical use or furtherance of for-profit business or for compensation.
It may under the commercial code, but not under the code otherwise.
It is under Kansas, correct?
It is not under Chapter 8 of the Kansas statutes or Chapter 40, which you're filed under. But we can address that at a later date at a trial or a motions hearing if necessary. But I do not see the statutory language that you're addressing being applicable to these statutes, at least preliminarily at this hearing.
It is within, sorry.
Okay.
Go ahead.
That's my ruling there. And then on the name issue, I am not tracking you there. The only difference I see is that at the top of the document, state of Kansas and your name are capitalized, and in the initial or in the individual charges, it's traditional capital letter of the first name, all lowercase of the remaining names throughout. So I'm not following that argument. Again, if you want to readdress that at a later date, we can, but I'm just not seeing that argument.
Okay.
Now
Well,
then,
I motion and move this court to dismiss this case for the motion I have filed and for the brief in support of motion to dismiss for lack of jurisdiction.
sir, I do not have any such motion or brief in support. Mr. Regier, have you received it?
It's starting to look like someone's in over their head. Our defendant believes in mailing the court counts as officially filing legal documents, despite being clearly told that's not how it works. There's a big difference between what you think is legally acceptable and what actually is. Court procedure matters. If you don't follow it, your arguments don't even make it onto the docket. And when your excuse includes ransomware, car, theft, and unclear addresses, you're not building credibility, you're building...
That I am not aware of.
Well, that's what I'm trying to decide, if it's properly before the court. Mr. Dubois, who did you file the motion and brief with?
Well,
did
seeing
you-
as your guys' e-file is down for what is it? It's called a ransom malware or something. I cannot e-file.
Right,
so
but you can mail it, or you can walk it into the clerk of the court. Have you done that?
Yes, I've mailed it. By email,
But-
which a
and I'm
court
sorry,
clerk
when I-
said I could.
Okay, go ahead, please. I'm sorry I interrupted you.
No, you're fine. It was by email, which the court clerk said I could, considering the e-file was down. And I
Alright.
can't really go 20-something miles to do that, considering my personal property was stolen.
You serious?
Judge,
When did you
to-
email it, sir? When did you email it?
A while ago.
Judge,
Yeah.
Yes.
we do not accept emailed filings, only faxed or by mail or person.
Okay,
I'm
I was
sorry.
told that they do not have fax, so I could not do that. So email would be okay.
He may have called the wrong courthouse then.
They spent 10 minutes finding my case because your guys' system was down. So I'm fairly
recall
certain it was
which-
the correct one.
Okay. Do you recall which you file or which court you called?
Let me go to my sent. T Stafford at bucokansas.com.
I think that might be at the county courthouse, not the district courthouse.
Okay. So
Is
if
it?
you want,
Okay.
if you want to file something, sir, let's make sure you file it in a fashion that will get it officially recognized. So Ashley, how do you suggest he file motions and the like?
He will either need to mail us a copy of it or he can fax file.
And is your guys' fax active?
Yes, it has been the whole time.
Okay.
It's
And
not affected, yes.
what's the fax number?
Our fax number is 316-321-9486.
Okay. And my honor, I have one last question. For the nature and cause of these charges, is it a criminal or is it a civil matter?
This is a criminal matter.
Okay. As is a criminal matter, there are two jurisdictions which I may be tried. One is the common law, and the other is a military tribunal. Which of those two do you intend to try me in?
I intend to try you in this one, sir.
Which is this one? Please elaborate.
The criminal one.
Well, criminal has two jurisdictions. It is either the common law or it is the military tribunal.
Well, sir, we're not going to go into that at this point.
Are you refusing to acknowledge to me and tell me the nature and cause of the charges?
I have told you the nature and the cause of the charges.
You are not elaborating.
I think the remaining issue, sir, is whether you're going to hire an attorney, apply for court appointed or represent yourself?
My Honor, I need to know whether or not this is going to be in the common law or a military.
Appointed or represent yourself, sir?
Again, I'm not representing myself. I am sui juris in proper persona or propria persona.
So you're not going to have an attorney, or are you?
No, I'm not going to be presented or represented by any British agent, registrant, or anybody else to be a ward of the state. I'm standing on my rights, and I do not abrogate them. And if you're going to continue to move this court without any sort of...
It's where the judge offers one last out. Get a lawyer. Save yourself from self-sabotage. But instead, the defendant doubles down with the classic "I do not consent to be represented by a British agent" claim. It's a predictable move in sovereign citizen circles, driven by the belief that legal representation somehow turns you into a ward of the state. But in reality, rejecting trained counsel doesn't make you free. It just makes your legal defense a trained